Welcome back to Law and Crime. For the next hour, I'm going to be joined by Ilya Shapiro. Ilya, hello, how are you?
Doing well. It's been an interesting week.
You are at the Cato Institute, which is kind of like a think tank, right?
It's not kind of. It is a think tank.
Right.
We cover public policy issues, the gamut of policy issues from a libertarian perspective.
And you've clerked on a Court of Appeals, the Fifth Circuit Court of Appeals, if I recall, correct?
Correct.
And my understanding is you're a big supporter of this nomination, correct?
I don't know, big supporter
You're
or not, but I am a supporter.
Let's take out the modifiers.
I think you'd make a fine justice.
Okay, so if you were testifying for him, you'd be on the side of testifying for him down there with people that are talking right now.
That's right.
Okay, so we're going to talk about that when we come back. But right now, I want to go back into the judiciary hearing because we have another person discussing what the temperament of Judge Kavanaugh is like and whether he's fit to be a Supreme Court justice. So this is Law and Crime, and that is Senator Chuck Grassley, who is the chairman of the committee, talking about the temperament that the last witness, Kenneth Christmas, discussed about Supreme Court nominee Brett Kavanaugh. Now, I'd like to bring our guest Ilya Shapiro in because Ilya has written a lot about different constitutional cases, constitutional law. Ilya, we've heard again a lot about temperament, but I simply didn't hear any views from Justice Kavanaugh. And when I look back at the Supreme Court history, we had some pretty bad cases. We had Dred Scott, which said that black people couldn't vote. We had the Korematsu decision, which interred the Japanese. I mean, we may have had nice people on the Supreme Court, but they had some pretty bad decisions. So how can we tell that temperament will make Judge Kavanaugh a good judge caring about the people and their common concerns?
Well, at the end of the day, I think senators can and should decide based on the jurisprudence. He has 300-some opinions, and if you agree with his legal theories, then that's great. And if you think that they're bad and would harm the Constitution or the rule of law, then vote against them. I think temperament is a plus. Collegiality is a plus. Having a type of personality that can work in what Judge Kavanaugh kept referring to as the team of nine.
Right, but we still don't know what his specific views are, except that he likes Brown versus the Board of Education. I mean, you tell me what his views are on Roe versus Wade, from what you've heard the last few days.
Well, I mean, all nominees never give their views on particular cases. That's not something that he invented. It's not something that Neil Gorsuch invented. It's not even something that Ruth Bader Ginsburg invented, and it's often referred to as the Ginsburg standard: no forecasts, no previews, nothing like that.
But should it change? Should it change? We should know what we're getting. If I'm buying a car, do I want to know if I'm getting a lemon or not?
Well, you have pages and pages of judicial opinions and law review articles and speeches. He's clearly an originalist and a textualist, meaning that he applies the text of the law. He applies the meaning of the Constitution when it was enacted, rather than what somebody might think might be its purpose or how it evolves over time. Some people think that leads to conservative outcomes, but there are plenty of debates among originalists. But look, he is one of the biggest paper trails of anyone that's been elevated to the court in modern times. So there's plenty to evaluate.
That may be true, except that one of the things that we look for, right, is that let's not deny this. This is going to be a vote in his favor. It's probably going to be a party line vote, that we're going to see the Republicans versus the Democrats, and he's going to get elected. He may turn out to be a great Supreme Court justice. We just don't know his views except in the opinions he's made, because he won't forecast anything like other justices. Is that right? You tell me. This is Law and Crime, and you just heard from 3 senators. You heard from Sheldon Whitehouse, you heard from Orrin Hatch, and now Senator Richard Blumenthal, who's a senator from Connecticut, where they had the Sandy Hook tragedy. Now, I'd like to bring our guest in, Ilya Shapiro. Ilya, again, we were talking about how Judge Kavanaugh reads the Constitution as it is, in the words, the textualism. Now, here is this young woman. Her name is Ayala Eastman. She's a survivor of Parkland, and she's talking about assault weapons. And apparently Judge Kavanaugh does not believe you can ban assault weapons under the Second Amendment. But they didn't have assault weapons back in, the 1700s when the Constitution was written. So how can you justify this textualism with saying, okay, I can't ban assault weapons as a judge?
Well, first of all, there's no such thing as an assault weapon. That's a not a legal or firearms term of art.
You bring a good point up, but the point is that the public thinks there are. It's these weapons that can kill people.
So
let's forget the handgun. It's a gun that's like bigger than a machine gun.
I mean, most gun murders in the United States are committed with handguns. That's the most dangerous weapon that we have, the one that commits the most injuries. And as far as machine guns, a lot of people think that when we talk about so-called assault weapons, that's machine guns. You press the trigger and, dozens of bullets fly out. Those are banned. So it's not about that. What we're talking about, and whether it's Newtown or these school shooting cases that come up, they're basic rifles. And as far as I know, what an assault weapon is something that looks scary. It's black. It has various attachments. Indeed,
I think we're going to have.
When we had the assault weapon ban,
to talk about this. I think we're going to have to talk about this when we come back from the break, Ilya, because I think the public thinks they're more than just a little scary. I think they think there's a weapon that can do damage. They're normal
rifles. The way that people are talking about are normal rifles, the most common ones.
So we're going to talk about this when we come back from our break. But one of the things, remember that we're hearing from a young woman who survived the tragedy. Think about it. We're going to go to break and talk about it on the other side. So we're back at Law and Crime, and we just heard again the senators discussing the testimony of the people before them, normal people who come before the senators who have normal jobs. They may be jobs that you or I don't do, but they're normal jobs. I mean, young kids who go to school, a school teacher, somebody who's a public defender. So I'd like to bring my guest back in, Ilya Shapiro, just to talk about what we just heard at the end. They were discussing a concept called mens rea in the criminal law. And mens rea is a concept that you have to know you're committing a crime before you can really be found guilty of it. Simply put, for people out there, I'm speeding, I'm going 50 miles an hour, I don't know it's a 35-mile-an-hour zone. It doesn't matter whether I have the mens rea to speed, it's just the action. So can you tell us, Ilya, because you do a lot of constitutional law, why this was important to discuss in terms of Judge Kavanaugh's judicial temperament and his opinions?
Well, sure. He's actually been quite strong in upholding the idea of mens rea, that if the government has not established that you have a guilty mind, that's what mens rea means, then you can't be prosecuted and convicted. It doesn't mean that you're ignorant of the law, but if you don't know what you're doing, and the government hasn't proven that you know what you're doing, then they can't convict you for it. So there are a lot of crimes on the books, both blue collar and white collar, that are technical violations, but people have no idea they're committing them when they're supposedly committing them.
Yeah, as a matter of fact, we have a case here. We have a case, let me tell you about it. There was an admission by Governor Cuomo here in New York that he picked up an eagle feather. I'm about to write about this on my blog. And took it home, didn't know it was illegal to pick up an eagle feather. I knew it's illegal because I'd been on a whitewater rafting trip once when I was told, don't pick up that eagle feather because you're going to go to jail. Are those type of things we're talking about, or is it something more serious that affects the normal person?
Well, it's a little different. That might be an example of over-criminalization, that is, making things criminal that the average person wouldn't think should be criminalized. Harvey Silverglate, a great civil liberties lawyer, wrote a book called 3 Felonies a Day, how all of us working professionals every day crossing state lines or whatever are committing all of these kinds of felonies. The mens rea stuff is more like you have this complicated crime that someone is allegedly committing, and the government doesn't introduce evidence that they know that they're doing something. For example, we were talking about guns earlier. If someone is carrying a normal rifle and they don't realize that it's actually a machine gun, and the government doesn't establish that they know it's a machine gun, then you can't be convicted of knowingly possessing a machine gun in violation of the law.
Well, except that if I'm thinking of a machine gun, I kind of know it's a machine gun generally.
No, you don't, because they can look just like I said. What people think of as assault weapons is purely cosmetic. It has no difference on the rate of fire, or the speed of the bullets, or anything else. So most rifles can be made to look as scary as machine guns.
But isn't the bigger problem, though, what they do? I mean, isn't that the whole point of the United States right now? People want to know, they want the Congress, legislatures, the judges to affect their real lives, to take their real problems into consideration and address them. Does this hearing move that forward?
That's not the role. That's not the role of the judge. That's the role of the legislature. What judges are supposed to do are to protect our rights. And one of those rights is to self-defense and
Okay.
to use
Got
weapons
it.
that are in common use.
All right, so we're going to continue this. This is a nice line. I don't know we're going to have much time afterwards, but the panel is seated now, so we're going to go back into the hearing room. Let's see who we're going to hear from next. Hi, this is Law and Crime. We've been listening to people testify to the senators about their experiences with Brett Kavanaugh. I have to thank my guest for the last hour, Ilya Shapiro, who is a senior fellow at the Cato Institute doing constitutional law, also clerked on the circuit court. Ilya, you've been great. You and I have to have a better discussion, more time next time.
Sure.
Because we were really getting into the different avenues, the different sides. But it's been great having you. Please come back. Right.
My pleasure. Take care.
One of the things is there's a lot more happening today on Law and Crime. There's a lot more testimony on Law and Crime. Aaron Keller is actually going to be sitting in the anchor seat pretty soon. And you don't get rid of me yet because I'm going to be his guest for the first half an hour. I know you can't believe it. So you can continue to answer those questions to both Aaron and I. The issue has become, is Brett Kavanaugh going to get going to be a Supreme Court justice? Is he? I want you all to weigh in. Is he and should he? Thank you. See you next time.